Okay, sir. Good afternoon, sir.
Good afternoon.
We are Biafra. I am Nuchago Chukwemeka Chimere from Biafra Writers. So, sir, we want to ask you first, what was really the outcome of today's court?
Actually, the matter came up today for the hearing of our application for stay of proceedings in district. Pending determination of appeal, we already filed for the court of appeal. Yes. And the application was heard and adjourned till 26th of April for hearing, for ruling.
Okay.
And the court has been addressed extensively on issues raised before the court. The reason why the court should stay this case, right, because issues raised before the court of appeal, and which we are challenging are constitutional issues that borders on the right of accused person to fair trial, which the court cannot proceed upon without the court of appeal being heard first and timing of upon it.
Alright, sir. So, the application, when will it be determined upon?
What?
When will the application be determined upon?
It's on 26th of April this month.
Alright.
Remember, we are going to court of appeal on 25th for hearing of appeal against the denial of the bail. So it's also coming up on 26th of April. So at the thereafter, we'll now come back on 26th for hearing of the ruling.
Okay, was it just for the denial of bail?
We have three appeals pending before the court of appeal.
Yes. One
on denial of bail. That one has been entered.
Yes.
And brief of argument has been changed. Then secondly, the one is on passport. The issue of passport is denied. It's British passport and Nigerian passport and the money. Then two is against the order of this court, where the court varied its order. So we have three appeals substantially before the court of appeal. But the one being coming up on 25th of April for hearing is the one challenging the denial of bail of the defendants. That one coming up on 25th of April. Okay,
during the court proceeding, I overheard Chuks Moma saying that the 20 minutes for his speech was not allowed. What really was happening?
It's not just to the whole world that the judge is also biased. That one is no longer in contest, because the right of adumbration is a right provided under our procedural laws, and you can overheard us, perhaps let's say, reading that before the court, and it's a mandatory right. There's no way courts will cut short of that right. So by stopping him from adumbrating his arguments for the court means that he's impeding on the defense counsel rights as governed by the rules of the court.
So it was reported that Nnamdi Kanu case was forwarded to ECOWAS court. So what do you have to say on that?
In ECOWAS court, when you file an application before the ECOWAS for the complaint, the defense or the defendants giving 30 days to respond. Up to now they've not responded to application before the ECOWAS court. And we have already approached them for a date for hearing. So which means by within the week they will communicate us on a date for the hearing of application before ECOWAS court.
You recently wrote a letter to the UK on 24th of March 2016. So can you throw more light on that, sir?
Well, speculation has gone over the places that Nnamdi Kanu is begging the UK government to intervene in the matter. No, that wasn't the sense of the letter. We are merely reminding the British authorities on their constitutional rights, on the rights of Nnamdi Kanu as a citizen of the UK. So govern under the UK laws and conventions. So they will not live up to that expectation. That's all. We are not begging them for anything more than that.
So what was their reply regarding the letter?
We are waiting for their formal communication. They are going to do a letter to us in that regard. But already before now, we have communicated with them. They called me on phone that they are looking into our case and they are also involved in the matter. They are getting involved in the matter too.
So do you actually believe that Nnamdi Kanu did beg as a British
the letter speaks for itself. We never beg for the British authority to get involved in the matter. As I said, we are reminding them of their constitutional rights of Nnamdi Kanu as a British citizen, because he's a British citizen too. He has rights to bear under the laws and conventions too, and that right must be protected. Privileges and privileges also. So that must be protected. We are calling them also to get involved. Because we are not begging on them, we are reminding them.
Okay, sir. To enter into Nigeria,
and especially on the face of obvious manipulations and maneuvering going on in this court. There is reason for the international community and authorities to get involved and also know what's happening. Because what's happening in the court is obvious to the whole world. That the judge in particular is biased.
Okay, sir. And, okay, so what will happen now if the Federal High Court delivers a different judgment, and the ECOWAS court are under? What will be? Which one will supersede each other?
The matter before the ECOWAS court is a different matter.
Okay.
Aside from matter before the Federal High Court, in the ECOWAS court, we will approach the ECOWAS court on the gross violation of Nnamdi Kanu's constitutional rights, as contained in Nigerian constitution, also under the African Charter of Human Rights, and also International Convention, which Nigeria is necessary to approach them, to complain to them about the violation of that right, and also seek compensation to that effect.
Sir, please, what do you have to tell millions of Biafra all over the world who are earnestly following the awaiting and the outcome of this legal battle between Nigeria and Nnamdi Kanu?
It's obvious to the entire world and the Biafran in particular that Nnamdi Kanu is being persecuted. And we believe in justice. We don't believe in self-help. And we must get to the root of it. We must judge based on available facts and evidence for the courts, not based on somebody's opinion or speculations or the minds of anybody. The matter will be judged based on facts and evidence and documents going before the court. So I'm urging them to remain calm, pending determination of the cases.
You've constantly hammered on the court being unfair to your clients. Now, what exactly does your legal team want the courts and the Federal Republic of Nigeria to do concerning this right now?
Well, in that regard, we have already filed appeal against the rule of the court of appeal. Part of our reliefs as contained in the said appeal is for the court of appeal to direct the CG of Federal High Court to transfer the matter to another court. You may not believe the ruling delivered by this court since 9th of February, 9th, 19th of February, and 7th of March has not been available to us.
And why was that?
It hasn't been made available to us. And that ruling is affecting the compilation and submission of record to court of appeal. Just like what happened to the court, we apply for stop proceeding and also file a letter to the court to process the ruling of the court to enable us to transfer the court. But up till now, the ruling has not been made available to us.
And why was that, sir?
What?
Why was that? Why has the judge hasn't delivered?
For reason best known to him. Constitutionally, the accused person only entitled for only 7 days to have copies of the ruling we have to complain of.
So if the judge goes against the rule, the order of the court, so what's next? Where will you head next? Because since the file has not been made available, how are you going to appeal for it?
No, it has no other option than to make available the ruling to us. Because part of the reason why, part of their complaint before the court of appeal, you must make the ruling available to us. He delivered the ruling in open court and must give it to us. It's our constitutional right. You can't deny us such right.
Okay, sir. Thanks for your time.
Thanks for your time, sir. That will be all.
Thank you.